Across America, a powerful movement is taking root. It is a movement born of principle, fueled by a deep respect for the Constitution, and driven by a refusal to bow to federal overreach. This is the movement for Second Amendment sanctuaries. In towns and cities, counties and states, Americans are drawing a line in the sand. They are declaring their jurisdictions as safe havens for the Second Amendment, places where unconstitutional gun control laws will not be tolerated. This is not a fringe movement. It is a groundswell of resistance against an ever-encroaching federal government. It is a testament to the enduring spirit of liberty that burns bright in the hearts of millions of Americans. They understand that the right to keep and bear arms is not just about hunting or self-defense. It is the bedrock upon which all other freedoms rest. This essay will explore the rise of Second Amendment sanctuaries. We will delve into their legal basis, examine the specific policies they resist, and analyze the pushback they face. This is a story about the ongoing fight for freedom in America, a fight that is being waged not just in courtrooms and legislatures, but in the hearts and minds of everyday citizens. Second Amendment sanctuary policies are, at their core, a declaration of resistance. They are a bold statement from local communities that they will not stand idly by while their constitutional rights are threatened. They represent a refusal by local governments to enforce federal gun laws that they deem unconstitutional. This movement has gained momentum in recent years, with more and more counties and municipalities joining the cause. These policies vary in scope and strength, but they all share a common goal: protecting the Second Amendment rights of law-abiding citizens. From symbolic resolutions to legally binding ordinances, the methods may differ, but the message remains the same. Some sanctuaries, like several counties in Nebraska, have passed resolutions stating their opposition to any new federal gun control measures. These resolutions are often the first step in a broader strategy to safeguard gun rights. These resolutions serve as a powerful message to Washington, D.C. that any attempt to infringe on the Second Amendment will be met with stiff resistance. They are a clear indication that local governments are willing to stand up for their citizens' rights. Other sanctuaries, like Columbia County, Oregon, have gone a step further. They have not only passed resolutions, but have also enacted ordinances that have real legal implications. They have passed ordinances prohibiting the use of local resources to enforce federal gun laws. This means that local law enforcement and other county officials are legally barred from cooperating with federal agents in actions that would violate the Second Amendment. This means that county officials, including law enforcement, are barred from assisting federal agents in carrying out gun confiscations or other unconstitutional actions. This legal barrier adds a layer of protection for gun owners in these sanctuaries. These are just two examples of the many ways in which Second Amendment sanctuaries are pushing back against federal overreach. Across the country, communities are finding their own ways to resist what they see as unconstitutional federal mandates. Whether through symbolic resolutions or concrete ordinances, they are sending a clear message: the Second Amendment will be defended at all costs. This movement is not just about guns, it's about the broader principle of local autonomy and constitutional fidelity. These policies are not about defying the rule of law. They are about upholding the Constitution, which is the supreme law of the land. By standing firm, these communities are asserting their right to self-governance and their commitment to the foundational principles of American democracy. The term sanctuary might evoke images of medieval churches offering refuge to those seeking protection from persecution. These sanctuaries were sacred spaces, where the persecuted could find solace and safety, shielded from the harsh realities of the outside world. The concept of sanctuary has evolved over centuries, but its core essence remains the same: a place of protection and security. In the context of the Second Amendment, the term takes on a similar meaning. It represents a modern-day refuge, a safe haven where individuals can exercise their rights without fear of government overreach. The Second Amendment sanctuary movement has gained momentum, with communities across the nation declaring their intent to uphold the right to bear arms. It signifies a safe haven from overreaching federal laws that threaten to infringe upon a fundamental right. Gun owners and advocates argue that these sanctuaries are essential in preserving their freedoms, ensuring that they can continue to own and use firearms responsibly. The movement is a response to what many perceive as an encroachment on their constitutional rights. The use of the term sanctuary in this context is no accident. It is a deliberate choice, meant to evoke the same sense of protection and security that historical sanctuaries provided. By adopting this term, Second Amendment advocates are drawing a clear line in the sand, signaling their commitment to defending their rights. It draws a parallel to the sanctuary city movement, where local governments refuse to cooperate with federal immigration enforcement. Just as sanctuary cities offer protection to illegal immigrants, Second Amendment sanctuaries aim to shield gun owners from what they see as unconstitutional federal gun laws. Second Amendment sanctuaries aim to shield gun owners from unconstitutional federal gun laws. This parallel highlights the broader theme of local resistance to federal mandates, a theme that resonates deeply in American history and culture. Both movements involve local governments asserting their autonomy in the face of federal pressure. City councils and local officials play a crucial role in these movements, passing resolutions and ordinances that declare their communities as sanctuaries. These actions are often met with both support and opposition, reflecting the divided nature of the issue. Advocates argue that the Constitution provides a clear framework for the protection of individual rights, and that any attempt to infringe upon these rights must be met with resistance. This belief is a driving force behind both sanctuary movements, and both are met with fierce opposition from those who believe in a strong central government. Critics argue that these sanctuary movements undermine the rule of law and create a patchwork of conflicting regulations. The debate is a microcosm of the larger struggle between federal authority and local autonomy. The use of the term sanctuary is both strategic and symbolic. It taps into a long tradition of resistance to tyranny and underscores the gravity of the threat to the Second Amendment. By framing their movement in this way, advocates are able to rally support and draw attention to their cause. It taps into a long tradition of resistance to tyranny and underscores the gravity of the threat to the Second Amendment. Throughout history, people have fought to protect their rights and freedoms, often at great personal risk. The Second Amendment sanctuary movement is a continuation of this legacy, a modern-day struggle to preserve the principles upon which the nation was founded. It is a powerful reminder that when the federal government infringes upon our rights, we must be prepared to stand up and defend them. The movement serves as a call to action, urging individuals to take a stand and protect their constitutional rights. In doing so, they honor the sacrifices of those who came before them and ensure that future generations can enjoy the same freedoms. The legal foundation of the Second Amendment sanctuary movement rests firmly on the 10th Amendment to the United States Constitution. This amendment, often overlooked but critically important, states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. In simpler terms, the 10th Amendment reinforces the principle of federalism. It recognizes that the federal government possesses only those powers explicitly granted to it by the Constitution. The Constitution gives no power to the federal government to regulate arms. All other powers are reserved for the states or the people themselves. This division of power is essential to preventing tyranny and ensuring that government remains accountable to the governed. The Second Amendment sanctuary movement argues, with strong legal justification, that the federal government has exceeded its constitutional authority by enacting gun control laws that infringe upon the right to keep and bear arms. These laws, they contend, are an overreach of federal power and a violation of the 10th Amendment. Kansas, for example, passed a law in 2013 declaring that any federal gun control measures deemed to infringe on the Second Amendment are null and void within the state. This law, upheld by the Kansas Supreme Court, serves as a powerful example of a state asserting its 10th Amendment rights to protect its citizens from federal overreach. The roots of this debate can be traced back to the early days of the American Republic, when the Founding Fathers grappled with the balance of power between the federal government and the states. The Federalist and Anti-Federalist papers, written during the ratification debates of the Constitution, highlight the intense discussions and differing viewpoints on the scope of federal power. Today, this historical debate continues to resonate, as states like Kansas take a stand against what they perceive as federal overreach. Legal scholars often point out that the 10th Amendment serves as a critical check on federal authority, ensuring that states retain significant power to govern themselves. This local governance is seen as vital for addressing the unique needs and concerns of different communities across the nation. The Second Amendment sanctuary movement is a modern manifestation of this ongoing struggle for state sovereignty and individual rights. Advocates argue that, by declaring themselves sanctuaries, states and localities are not only protecting gun rights, but also reaffirming their commitment to the principles of federalism. This movement is part of a broader historical context, where states have often pushed back against federal mandates, whether on issues of civil rights, healthcare, or education. As the debate over states' rights and federal overreach continues, the 10th Amendment remains a cornerstone of American constitutional law, reminding us of the delicate balance of power that defines our federal system. Ultimately, the ongoing dialogue about the Second Amendment and states' rights underscores the enduring importance of the Constitution in shaping the nation's legal and political landscape. It is a testament to the dynamic and evolving nature of American democracy, where the voices of the people and the principles of the Constitution continue to guide the nation's path forward.